Welcome to the South Carolina Courts. This video was developed by the South Carolina Access to Justice Commission along with the South Carolina Bar to provide you with a basic understanding of the court system so that you are prepared to present your civil case in court. The doors to the courthouse are open to everyone, and the law allows you to represent yourself in court. However, the laws and rules that govern our courts can be complicated. Only an attorney can properly advise you of your legal rights, provide legal counsel, and act on your behalf. It is important to note that this video is not a substitute for legal advice. To protect your legal rights, you're strongly urged to consult an attorney. If you choose to proceed without an attorney, it is important to note that court officials and court clerks cannot give you legal advice or advise you on how to prepare your legal documents. You will need to do your own research to prepare your case. People who represent themselves in court are known as self-represented litigants or pro se litigants. Pro se is simply a Latin term meaning in person or on one's own behalf. Proceeding as a self-represented or pro se litigant can be an intimidating experience. The following scenarios are intended to help you prepare for your day in court and feel more comfortable with the court process in South Carolina. Coming to court can be an intimidating experience. Most people are nervous when they have to come to the courthouse. The number one rule when coming to court is to be prepared. Here are some tips to keep in mind when coming to court. For your safety, expect that you will have to go through security. To make this process faster, leave all of your metal items at home or in your car. Now, parking may also be an issue depending on the county where the courthouse is located, so arrive early. To save yourself a trip, bring all relevant paperwork and documentation that you will need, whether you are at court for a hearing or to file papers. Court is not a place for children, so arrange for childcare ahead of time. Arrive at the courthouse at least 30 minutes prior to any court hearings. Or if you are coming to the courthouse to file papers, expect that the process may take longer. Some court forms are available online, and to save time, it's a good idea to fill out the appropriate forms before coming to the courthouse. While necessary forms are available in the Clerk of Court's office, you may be required to pay a fee to copy them.
Hi, I was wondering if you could help me with something.
Oh, I actually don't work here in the courthouse, but I am a law student and I worked here last summer, so I'll try to help you as best I can.
Okay, well, I received these papers and I'm not really sure what I should do with them. Should I hire an attorney? Are they expensive?
Well, I can tell you that in all cases, it is very beneficial to discuss it with a lawyer, especially since lawyers are trained to help you. A lawyer will be able to tell you what the law is for your particular problem, what your legal choices are, as well as how best to handle your case. And contrary to popular belief, lawyers aren't always expensive. As a matter of fact, you may qualify for free legal representation or representation at a reduced cost.
Yeah, I heard a good starting point is South Carolina Legal Services. I called them, but I didn't qualify.
Yeah, in order to qualify for South Carolina Legal Services, your income must not exceed 125% of the federal poverty guidelines. You could also try the South Carolina Bar's Lawyer Referral Service. It's a service that allows you up to a 30-minute consultation with a lawyer that's licensed to practice in this state.
Unfortunately, I simply can't afford an attorney. Not at a reduced rate, especially not in this economy. So I guess I'm just pretty much on my own.
Well, in that case, I'll try to point you in the right direction.
Hey, I noticed security was pretty tight. I'm glad I got here early.
Yeah, that was really smart. A good rule of thumb is to be at the courthouse at least 30 minutes prior to your case being called. And if you're here to file papers in the Clerk of Court's office, you can expect that that process will take a little bit longer than you anticipated. This is your first trip to the court, right?
Yes, and hopefully it'll be my last. But right now I have these papers, and I don't really know what they mean.
Looks like you've been served with a summons and complaint, which basically means that someone is bringing a civil action or a civil lawsuit against you.
Yeah, the document said that I should respond to this in 30 days and serve a copy on the other party. I'm not sure I really understand everything, but I did put something together. I'm just wondering now if I should come back in a few weeks.
It is extremely important that you file your answer within the 30-day deadline. Otherwise, the opposing party may get everything that they're asking for.
Well, I guess in that case, I better go ahead and file my answer. I just want to get this over with.
Well, unfortunately, your case will not be resolved today, and this trip to the courthouse probably won't be your last. You may have several other hearings prior to the disposition of your case, and you may not see a judge every time that you are here.
I guess I need to file the answer myself. How do I do that?
Well, you can do that in the clerk's office, which is right over here.
Remember, it is always beneficial to hire a lawyer if you can. If you choose to go forward with your case or on your own, be prepared. The person bringing the suit in a civil case is called the plaintiff, and the person defending the suit is called the defendant. To begin the case, the plaintiff files a complaint with the court and serves it on the defendant. The defendant then needs to reply with an answer within 30 days from the day of service. After the paperwork is filed, you may be required to come to court more than once in the course of your case.
Hello, can I help you?
Yeah, hi. I received this summons and complaint. I'm not really sure I know what to do with them. I tried to answer all the questions in the complaint, but I'm not sure about number 7. Does that look right?
I'm sorry, sir, but the clerk of court's office can't help you in preparing the answer. That would be like providing legal advice, and I'm not able to do that.
Well, maybe I can speak to the clerk of court. Her name's on the stamp, and I figured maybe she could help me since she must have something to do with this case.
The clerk of court's name is actually stamped on every document that's filed in this office, but she's not a party or involved in the action. She's simply the keeper of the record.
Okay, well, should I have answered this question? I wonder if it's going to affect my case.
Again, you're asking me to provide legal advice, and the clerk of court's office can only provide you with basic legal information. We've actually developed a chart that will help you determine the difference between what is legal advice and what is legal information. For example, we can provide you with answers about how the court works. We can provide you with telephone numbers to organizations where you might be able to get legal information. We can point you to court rules and deadlines and give you information about scheduling. And we also can provide you with basic information about your own case file, as well as court forms and available instructions.
Thanks. That's helpful to know. I'm beginning to understand that the clerk's office can only provide basic information.
That's right. The questions you were asking me earlier would have required me to give an opinion, and that's the same thing as providing legal advice. But there are a couple of other things that the clerk's office staff is not able to do. We can't tell you what to say in your court papers or to say in court. We can't give you an opinion about what might happen if you bring your case to court. We can't talk to the judge for you, and we can't let you talk to the judge outside of the courtroom.
Well, I guess I want to file this document. I've also been told that it's very important that I keep any documents I file with the court so I can bring them back when I appear in court.
Oh, that's very true. Now, in most counties, you can make copies in the clerk's office, but you should be prepared to pay a small copy fee.
Okay, now that my papers are filed, I have a few questions I would like to ask the judge.
Well, filing your papers is actually the first step in the process. You cannot talk to the judge until your trial or hearing. You'll actually receive a notice in the mail from the clerk of court's office letting you know when you should come back to court, and then you can talk to the judge.
Okay, thanks.
All right, thank you.
Remember, you will need to file court papers in the clerk of court's office. There are also forms that you may need to fill out and costs associated with filing papers in court. Staff in the clerk of court's office will be able to provide you with basic information and check your forms for completeness, but they cannot give you legal advice. Make copies of all paperwork, keep it in a safe place, and bring it to court with you. If any necessary information is missing, you risk your case being dismissed or rescheduled. Remember, filing your paperwork with the clerk of court's office is just the first step in the process. Many court papers must also be served upon each party of record. This process is known as service of process, or serving papers, and is an important step in your case. In the scenario we've been watching, the litigant filed an answer to a complaint with the clerk of court's office. According to South Carolina court rules, the litigant must also serve a copy of the answer and any additional court papers on each of the opposing parties no later than 30 days after he receives the summons and complaint. Typically, the litigant would serve a copy of the answer on each party's lawyer. However, if the opposing parties do not have lawyers, then the litigant can serve a copy of the answer on the opposing parties themselves. For more information about service of process, please review Rules 4 and 5 of the South Carolina Rules of Civil Procedure very carefully.
Well, today's the day. Thanks for meeting me here today. I'm a little nervous, but I think I'm pretty prepared. Did I dress okay? I didn't really go out and buy anything new.
You look great, and you don't need to buy anything new for court. Just make sure to dress respectfully. As long as you aren't in a t-shirt, shorts, torn clothing, or flip-flops, you'll be fine. But before we enter, make sure to turn off your cell phone. It's extremely important because if it rings, the court can actually take your phone and make you pay a fine. Well, I guess this is where I leave you, so good luck.
Thank you.
Court order, please. All right.
Thank you, ladies and gentlemen. Please take your seats. Welcome to Circuit Court. We are here for a civil action today. In South Carolina, courts are divided between common pleas or circuit court and general sessions or criminal court. Mr. Smith, I see you are not represented by an attorney today. Would you please stand? Do you intend to represent yourself today?
Yes, Your Honor.
Okay, you can take a seat. As you may be aware, if you are going to represent yourself, you will be held to the same standards as an attorney would be. But because you are an unrepresented party, I will take some extra time to explain some basic courtroom procedures for you. Now, many people have preconceived ideas about what courtroom procedures are about. A lot of us watch reality TV, and so they base their ideas on those perceptions of reality TV and dramas. Those courtroom scenes are depicted on the screen for your entertainment. That is not the way courtroom procedures work in reality. In reality, court procedures and hearings are very different from what you see on TV. There are rules and procedures that must be followed. These procedures are designed to make sure that everyone gets a fair opportunity to be heard. The judge will give each side an opportunity to have their story presented in court. Now, it's important to keep in mind when speaking to a judge that some of the things that you might think are important, the judge may or may not consider in his or her decision. It is important that everyone in the courtroom, just as well, treats all involved in the process with dignity, respect, and courtesy. For purposes of our proceedings today, first, I will listen to the plaintiff's attorney to see what he has to say about the plaintiff's case, and then, of course, I will give you an opportunity to speak on behalf of yourself as the defendant. Please do not interrupt each other. Our court reporter has to take down verbatim all of the proceedings in this courtroom, so you'll need to make verbal responses. The court reporter cannot record head shakes. Everyone will have their opportunity to address the court, and please be respectful of each other. Plaintiff's counsel, you may proceed.
Let's get acquainted with the people who may be present in the courtroom. There will often be many people in the courtroom. Some of them will be there for your case. Some of them will be there for other cases, and some of the people work at the courthouse. If you are filing the action, you will be referred to as the plaintiff in court documents. A person who is opposing the action is referred to as the defendant. The party bringing the action must convince the judge or jury by evidence that his or her position is legally correct. The person in the red jacket is called a bailiff. The bailiff makes sure that everyone follows court rules about how they should act. Many times there are also police officers in the courtroom. The police officer is present to make sure that everyone is safe while court is going on. You might also see a person typing or recording information in the courtroom. This person is the court reporter and is responsible for writing down everything that is said to the judge. If one or both sides in a case cannot speak English, either may request a court interpreter who will sit at the side of the person for whom he or she is interpreting. Usually there are also lawyers present in the courtroom unless all the parties are self-represented. There will likely also be other litigants in the courtroom waiting to be heard by the judge. The judge sits in the front of the room. Everyone is usually listening to what he or she says. The judge may also have a law clerk who is a lawyer who offers assistance to the judge during the trial or hearing. Normally, a jury typically consisting of 12 jurors for circuit court will be selected and sworn prior to the presentation of the case and will sit in the jury box to the side of the judge. Keep in mind that courthouses can be arranged differently and that the jury box can be on either side of the judge.
Please describe the events of December 19th.
Judge, this line of question isn't even fair. I wasn't even in town on December 19th. Besides, she doesn't know all the facts.
Mr. Smith, I note your objection, but
Judge, I've also got these facts. If I present them, this case is cut and dry.
Mr. Smith, you must remember that only one person can speak at a time. You have to demonstrate respect for these proceedings and everyone involved. Only one person can speak at a time. I also must remind you that the court reporter has to take down everything verbatim. I assure you that each side will have an opportunity to present their case to the court. Let's proceed.
When addressing the judge, stand and refer to him or her as Your Honor. Speak clearly, loudly, and slowly, and please don't speak when someone else is speaking. Everyone will have their opportunity to talk to the judge.
Mr. Smith, are you ready to proceed?
Your Honor, I have my paperwork, but my witness was supposed to be here by now.
Mr. Smith, please stand when you address the court. It is now your opportunity to present your case, and I see that your witness is not here at the moment. Do you have any other testimony or evidence that you wish to present at this time?
When it is your day in court, come prepared and organized with the appropriate evidence. Evidence consists of material that you will use to prove your case to the judge. Evidence can be medical records, receipts, bills, photographs, and original documents such as contracts, wills, and the like. A witness is someone who will back up your story. It is very important that your witness arrive on time and be dressed in appropriate business clothes. Here are some additional tips when addressing the court. Always wait for the judge to ask you if you are ready. When you are ready, stand and state whatever relevant information you believe the judge needs to hear to make his or her decision. Remember that the judge only wants to hear about facts and proof. It doesn't matter what you think happened. It doesn't matter what you think should happen next. What matters is what you can prove. Sometimes the judge might interrupt to ask a question. Listen carefully and answer the questions the judge asks you.
Now I have considered the position of both sides, and I am ready to make my ruling.
At the end of the hearing, the judge will tell you his or her ruling and will issue a more formal order, but it may be at a later date. It is very important to listen carefully so you understand exactly what the judge orders. If you don't understand, you may respectfully ask the judge to explain. Make sure you keep a copy of the written order for your records so that you may refer back to it if needed. Now, this is a lot to remember. Know that lawyers and judges do this work on a daily basis. If you have questions about what is happening during your proceeding and you have a lawyer, ask your lawyer to explain what's going on. If you do not have a lawyer, then politely ask the judge if you can ask a question. Don't be afraid to ask questions about anything you don't understand. Here are some do's and don'ts about the courtroom. Don't wear a hat in the courtroom unless for religious or medical reasons. Don't drink, don't eat, don't smoke, and don't chew gum while in the courtroom. Don't bring drugs or alcohol into the courtroom. Don't use drugs or alcohol before you come to court. Don't bring guns, knives, or any other kind of weapon to court with you. Don't bring your cell phone or pager with you to court. If you do, turn them off before you walk into the courtroom. If your phone rings or disturbs the proceedings, court officials may take your device and may make you pay a fine. Don't talk while other people are talking in court. Don't shake your head or sigh loudly when you don't like what somebody else says. You will have your chance to talk, and when it's your turn to talk, do stay calm. Do talk loudly enough for everyone to hear you. Don't yell and don't curse. Do dress appropriately. Don't wear shorts, short skirts, flip-flops, low-cut tops, sleeveless shirts, or shirts with inappropriate words or images on them. Do dress neatly. You don't need to purchase new clothes, but be clean and neat. Do get to court on time. Do arrange for child care prior to coming to court. Do bring all evidence and witnesses. Do stand up when the judge enters the room, and do remain standing until the judge says you can sit down. Because each county is different, do make sure you follow any additional rules specific to that court. The law and the court process can be complicated. Lawyers are trained to help you. There are several resources that may be helpful to you in finding free or low-cost representation, including the South Carolina Legal Services Intake Office, known as Lattice, and the South Carolina Bar's Lawyer Referral Service. The lawyers in the South Carolina Bar's referral program are all in good standing with the South Carolina Bar. They're licensed to practice law in South Carolina, and they maintain malpractice insurance. If you elect to represent yourself in a civil action, review this video carefully to prepare. In addition, there are other resources available on the South Carolina Judicial Department's website, www.sccourts.org. The South Carolina Judicial Department and the Access to Justice Commission have taken many important steps to better serve the self-represented, such as adopting standardized court forms and placing court-approved self-help resources on the Judicial Department's website. Remember, South Carolina Legal Services, the South Carolina Bar, and your local librarian are also great resources for you to use to prepare for your day in court.